The Court of Justice has been asked to consider again what a member state has to demonstrate to put the cost of a VAT dispatch fraud onto the trader, rather than allowing the trader VAT relief and absorbing the cost of the fraud in the public finances. A dispatch fraud works like this. The idea is probably very familiar, as it's been a big problem in EU VAT for many years now. A trader buys some goods in the domestic market, paying VAT and claiming it back as input tax, and then sells the goods to a trader in another member state, claiming exemption with deduction for an intra-community dispatch of goods on the basis that the customer is a VAT-registered trader in another country who will account for acquisition tax in that member state. There are various versions of this fraud, but in the one considered in the recent case, the problem is that the goods never leave the country. So the conditions for exemption aren't met, and the seller should really account for output tax. That's a little different from the situation in which the tax authority denies the input tax deduction to the seller on the basis that the goods did leave the country, but the seller knew that the transaction was connected to fraud. The problem is, of course, that different people can be involved in the fraud, and some of the parties may be innocent and not deserving to be punished, and finding out the facts is going to be hard because no one is going to confess. The tax authorities will try to pass the pain to the person that they can find, who is usually the seller in their country. That person will have claimed input tax and not accounted for output tax, and the tax authority will either assess them to deny the input tax or assess them to collect the output tax. It may be that it's the customer who's guilty and the seller is an innocent party. They may have been foolish and accepted the customer's assurances about the transaction, or they may have been convinced by a very well-executed fraud. The courts have held that a seller at the foolish and innocent end may be denied input tax credit because they may have had the means of knowing that there was a fraud. They failed to pick up on telltale signs and failed to ask questions that would have revealed what was really going on. Of course, it may also be that both parties are guilty. It's still always going to be easier for the authorities to pick on the seller because the seller is the one who's actually made a VAT return. They aren't missing and in a different country. But it's quite hard to prove that the seller was in collusion with the customer. It's easier for the tax authorities to have a different rule that simply denies the VAT relief, the deduction for input tax or the exemption for the dispatch, if there's something wrong with the transaction. So that's the question before the Court of Justice. If the authorities can't prove, or don't want to try to prove, that the seller is guilty of involvement in the fraud, can they still take the tax off them? What conditions can be imposed on an innocent trader who has been duped by a fraudulent customer? The main leading case on this is Telios plc, and the recent case of Traum has confirmed that the decision still stands. Telios was decided by the Court of Justice in 2008. The case was referred by the UK courts, and it related to the standard mobile phone missing trader fraud that was prevalent at the time. Most of the cases of mobile phone fraud led to an assessment to deny input tax deduction for the seller, but in this case the UK tax authorities decided to assess for output tax instead. A number of UK companies treated sales of mobile phones to a Spanish customer as VAT-free. HM Revenue and Customs decided that some of the documents provided contained forgeries and came to the conclusion that the goods had never left the UK. They therefore assessed the companies to output tax on the basis that they had made normal domestic supplies and weren't entitled to treat them as exempt with credit for input tax. The Court of Justice ruled that the mere fact that the goods had not left the territory wasn't enough on its own to transfer the loss to a supplier who was acting in good faith. As long as the supplier took every reasonable measure in his power to ensure that the intra-community supply he was effecting didn't lead to his participation in evasion, he should benefit from the exemption for his sale that the law provided. It would be for the National Court to decide whether all those reasonable steps had been taken. The Traum EOOD case was referred by the Bulgarian courts and was decided late in 2014. A Bulgarian trader exempted dispatches to a Greek trader. At the time, the VIS database showed that the customer was registered for VAT in 2005, and the Bulgarian authorities accepted that the documentation justified the exempt treatment. Later, it became apparent that the customer didn't declare the acquisitions in Greece and didn't account for VAT there. The VIS database showed that the registration had been cancelled with effect from 2006. The Bulgarian authorities therefore assessed the supplier to recover the VAT that had not been accounted for on the dispatches. The authorities said that the trader had proven neither the authenticity of the signature on the documents submitted in support of its declaration in respect of the supply it claimed to be exempt, nor that the person who signed those documents on behalf of the purchaser had the authority to represent the purchaser. These were extra conditions that were not initially imposed on the trader when the authorities had at first accepted that exemption was available. The Court of Justice referred back to cases including Telios and Mexec Gabona. It was contrary to the principle of proportionality to hold a supplier liable for deficiencies in the VIES database when a number was cancelled with retroactive effect. The principles of effectiveness and legal certainty precluded a member state from introducing extra requirements for a trader after documentation had been accepted because there had been a discovery of fraud of which the trader did not and could not have knowledge. As usual, the facts were for the national court to determine. If it could be established that the supplier knew or had the means of knowing that the transaction was connected to fraud, then the right to deduct input tax would be lost. There was nothing in the order for reference to suggest that this might be the case. That's not confirmation that the tax authorities didn't suspect the seller of being involved, but they may have been unable or unwilling to try to prove it in court. The Court of Justice has by this decision reminded tax authorities once again that they have to have the right proof if they want to deny the direct effect of the exemptions for dispatches in Article 138.